or a shady magistrate that had released the person or discharged the person, there might be grounds then, if they look at the depositions and they found that indeed this is a case that ought to go up and they look like they got some skullduggery here, that is where generally this power of the DPP became very valuable. And indeed, as a result of that, they will then do the order, ask and then commit to the High Court. Mr. Speaker, but notwithstanding all of that, there is this process that the law evolves. And it evolved in that way of whereby this provision, Section 72, was highly regarded because of the fact that certain judges of tremendous quality gave it an authority. And that set of judges dealt with the matter in a case very important. I think it was Williams. And the very important judges of that case comprised some of the most brilliant legal minds. Chancellor Haynes, Justice of Appeal Crane, and Justice of Appeal Messiah. And this matter came before them where they had to test the constitutionality of that Section 72. And for good reason at that point in time, and probably because of the advocacy of the lawyers then, they managed, because it was an extremely nice point, really good jurisprudential point, they decided that they are going to regard it as constitutional still. And the reason was given by Chancellor Haynes, and that reasoning was also redone by the president of the CCJ, Mr. Saunders, at page, I think it is paragraph 49 of the judgment. Because this excited a lot of constitutional law at the CCJ. Chancellor Haynes' response to that submission was unequivocal. I'm quoting from it. What the Chancellor expressed is more nuanced than the question as to constitutionality. The Chancellor had no doubt whatever that Section 72 is inconsistent with the right to a fair hearing guaranteed by the right to protection of the law. In his view, however, and this is the point I wish to make, the law was validated only because it was an existing law. And as such, its constitutionality was saved by the savings provision for existing law then found in Section 18 of the Constitution. In our new Constitution, it is now Article 152. So when DPPs used that power, and when the Court of Appeal recently held indeed, prior to this matter going to the CCJ, that indeed it is still constitutional, they were resting their case on very good authority via that Williams matter, and especially the judgments, erudite judgments, you might say, of Chancellor Haynes and, of course, Justice of Appeal Crane. And so because our Constitution makes provision for an existing law, which saves all the existing law prior to the Constitution coming into being, and this was one such law, I think they argued, or was argued before them, they then say that, okay, there is a certain element of it that might strike unconstitutionality, but because it was there prior to the Constitution and laws prior to the Constitution coming into being must be saved, otherwise we will not have a legal regime or a legal architecture, it is so saved. That is putting it very simplistically. And so this section was saved. And we had it right up to when the matter came in the Bishram's case. And in the Bishram's case, as was mentioned just now, by the learned Attorney General, it is important that this argument was taken to even a higher level, and I must congratulate the lawyers that made appearances in the CCJ that took this argument to that very high quality level. Mr. Darshan Ramdani, Queen's Counsel, and Sanjeev Dattadin, Dexter Todd, Arudranath Gosai. Not that Ms. Shalimar Haq and the rest of her team did anything badly. They maintained the precedent of the Williams case, but of course, the court then started this process of questioning the constitutionality of it for the very first time, right up to that point, where they then concluded that indeed it was unconstitutional. And of course, as mentioned, they themselves in the CCJ decided that this must be modified. And of course, they suggested a modification. I am happy to see that substantially that modification has been implemented in this bill. I'm also going to state that I am also impressed in the sense that the two other sections that deals with the issue of the DPP having a right to kind of overrule a magistrate, and the other two matters, the amendments to section 78 and 79, which correctly have been called consequential amendments, have been done at today's date, so that at least we could get a complete overhaul to the extent of making that which was unconstitutional now being constitutional. The judiciary, in the sense of judges being given the power now to ensure that they deal with this matter of prima facie case rather than the DPP, I think is putting it and residing it in the proper place. And I totally agree too that it should not be ex parte. There is a natural justice principle that should remain for the accused in any serious matter where imprisonment and even hanging are the penalties, that they should be given that right to be heard. And so, although there might be a little variation from that which was suggested by the CCJ, I believe that that variation is commendable in the form that it has taken here by virtue of this bill. And so to that extent then, I want to also commend the bill for passage in this House. I remembered very many occasions, and not only whilst being a prosecutor in the DPP's chambers in those years, but also on the other side, the defense counsel. And you could remember the treason case, the Maikoni treason accused, and a lot of things being said there where no case submissions were made by the defense counsel at that point in time, Bernardo Santos, and it being overruled. And then, of course, a long time in jail, they came for trial, and of course, the no case submission was upheld. Simply because if you had certain, evidence rather than what you call that which is taken as a deposition level, you could have avoided those lengthy incarcerations. And so there is an element of justice that I see forthcoming from the CCJ's rationalization and expounding I see also the need to start thinking about those unconstitutional existing laws that might soon be challenged and impugned in our courts, not only this Section 77. And to that extent, then, it is a good precedent for the purposes of ensuring a greater entrenchment and enshrinement of fundamental rights, fundamental human rights, whether they be substantive rights or whether they be procedural rights. And in the context then of the bill coming here, in accordance with that which the CCJ ruled, and also the consequential or the amendments in accordance with what the CCJ ruled, I could only concur with the AG at this point and support this bill completely. Thank you very much.
Thank you very much, Honorable Member. I think the case you were referring to was Dave Karan, Wordsworth, and Pratap Singh, if I'm correct. Honorable Member, Minister of Tourism, Industry and Commerce, Monish Waldron, you have the floor.
Thank you, Mr. Speaker. Mr. Speaker, I am pleased and indeed privileged to add my voice in support of this bill, the Criminal Law Procedure Amendment Bill number 21 of 2022. As ably explained by my colleague, the Attorney General, and the Honorable Member, Senior Lawyer, Mr. Ramjatan, Section 72 of the Criminal Law Procedure Act was found by the CCJ to have been repugnant to the Constitution of Guyana. This bill is intended to remedy that mischief. Mr. Speaker, despite the fact that we have before us here is a brief and simple bill, the case which was brought here, which has brought us here, and the jurisprudence underlying it are monumental and far-reaching. The case of Marcus Visram versus the Director of Public Prosecutions, which has led us here, touches upon profound issues relating to the fundamental values we hold as a democratic society. Mr. Speaker, the Visram case revolved around Section 72 of the Criminal Law Procedure Act, which was enacted here in Guyana in the year 1893, that is to say almost 130 years ago. Under certain circumstances and subject to the Director of Public Prosecutions having followed stipulated procedures, Section 72 conferred on that office holder the right to direct a magistrate to commit an accused to stand trial in the High Court for an indictable offense at the conclusion of a preliminary inquiry. This remarkable power was exercisable by the DPP even after the magistrate, having duly heard the evidence, would have made a determination that that evidence in its totality was insufficient to justify committing the accused. I myself, having sat on the bench as a magistrate for almost a decade, have had similar experiences, Mr. Speaker. Mr. Speaker, the DPP was entitled to exercise this power only after having obtained and reviewed the depositions in the case, and where such review led the DPP to form the opinion that the prima facie case had been made out and that accused should stand trial. Mr. Speaker, in contemporary society, this is indeed an extraordinary provision in many respects. The power conferred on the DPP raised a number of issues which were examined by the courts. Despite the comprehensive treatment of the matter by the Attorney General, I shall traverse some of these issues in no particular order, because they are fundamental to our claim to a place among civilized states based on a democratic order. The first issue of note, Mr. Speaker, is the independence of the judiciary. Independence of the judiciary, Mr. Speaker, is one of the fundamental features of any society that claims to respect the rule of law. The court found, unsurprisingly, that the power of the DPP to instruct a judicial officer, that is to say the magistrate, as to what outcome to reach in a case infringed on this independence of the judiciary. In coming to this conclusion, Mr. Speaker, the court expressly disagreed with the contention that the magistrates' courts were not included in the section of the judiciary whose independence was protected under Article 122A of the Constitution. The court also considered the issue of separations of power and made a subtle but significant distinction between the issue of independence of the judiciary and that of separation of powers. Mr. Speaker, when we speak of independence of the judiciary, we many times think instinctively that this is an issue to do with separation of powers. This is because the question of independence from whom, and we usually tend to frame our thinking in terms of independence from the executive. But threats to the independence of the judiciary may come from many quarters, including, for example, non-state actors such as defendants in criminal cases. It is not unknown, Mr. Speaker, for criminal defendants to attempt to intimidate judicial officers, where threats are made to the physical safety of judicial officers. These can compromise independence. That is why we afford state-funded security to judges. On the issue of separations of power then, the court treated at some length in its judgment the issue of independence of the DPP from